everybody, good evening. This is Advocate Sanya again with a series of lectures for you on a daily basis, especially if you're a judiciary aspirant. And I'm conducting these lectures on behalf of Oliveboard. So, welcome aboard. We're waiting for more of you to join in before we officially begin. So the way we are going to proceed with this is that I am going to keep checking the chat box. And however you want to question me or interrupt me in the middle and ask me your queries, just put your questions in the chat box. I'll keep checking it to see if I could resolve your query then and there or wait till the end of the session to do that. Today, we're going to talk about important case laws of 2021, and we all know how difficult it is to read those lengthy judgments. And this year, in 2021, Supreme Court came up with 865 judgments. So, of course, it's not really even expected of you to go through each and every one of them. We have condensed them and try to bring to you some really significant and interesting judgments of 2021 that will help you in your entrance exams. And even as a legal professional, they will help you in understanding and keeping up with the law, with the developments, with the precedents that are being set and the precedents that are being overruled. So let's begin. Okay, before I forget, sorry, I forgot to mention this. Olive Board has come up with really, really comprehensive and amazing judiciary courses, and you can check them out on their official website. The links are given in the description box. And if you like the courses, if you would like to enroll in them as a judiciary aspirant, as somebody who's just starting their preparation, or somebody who's looking for some guidance in their preparation, you can use the code SANYA, that's right on your screens, SANYA, and get flat 45% off. Okay, now let's go on with the topic for the day. Today we're going to talk about important case laws of 2021, as I've just told you. My name is Sanya Arora. I'm a practicing advocate in Delhi NCR. I've been practicing for over 3 years now. So you can learn more about me by going on my social media channels. That's Law Chakra by Sanya. Okay, so let's begin. The very first judgment, so I've tried to arrange these judgments in a chronological manner. Remember, the list is not exhaustive. So that means that each and every important judgment is not going to be discussed today. We are just going to go through some bullet pointers just to give you a brief background on these judgments, enough for you to want to go through them or to read analysis or to maybe even do your own analysis of those judgments. But we will go through some significant pointers and give you a brief background on these cases. It's not an exhaustive list, so all important case laws might not be there in today's presentation, especially since we have very limited time together. So, if you think there is some significant judgment that everybody should know about, please put that in the chat box and let's learn and grow together. So, very first judgment that we're going to discuss is, of course, the Central Vista project. That was the first major judgment that came out in 2021. It's titled Rajiv Suri versus DDA and others. I have given you case numbers of every important case that we're going to discuss today. So, over here, as you can see, it's transferred case civil number 229 of 2020, and it was decided on 5th January 2021. So the reason I'm giving you the case numbers is that you can go to the official website of Supreme Court and download the judgment on your own to go through it in depth using this case number. So it was about Central Vista project. So the petitioners had challenged the Central Vista project, saying that all the compliances and all the clearances were not taken, and this is a major, policy mistake by the government, especially during the time when COVID cases were on the rise, and so investing that kind of money on this project, and also the fact that it aimed to redevelop and construct completely new buildings out of historical buildings that were like Rashtrapati Bhavan and India Gate that had been standing since 93 years. So those were the major contentions that were taken by the petitioners, and that environmental clearances had not been obtained, and also historical conservation committee had not been uh, taken into consideration. Their advice, their consent was not sought. So those were the main contentions. The majority decision that came out of this was that the Supreme Court can interfere when it comes to judicial review. They can interfere if there is a contravention of the law, if there is a constitutional, if it is extra constitutional, then they can interfere and they can pass a judgment. But if it is just a bad policy decision, then the Supreme Court cannot interfere. It was a three bench decision, and that becomes very important when you are studying for your entrance exams, not just judiciary but also LLM entrance exams, LLB entrance exams. So the bench, the size of the bench, how many judges were there, and if there was any dissenting judgment. So all of those things become very important. In this case, it was a three bench judgment delivered by A.M. Kanvilkar, Dinesh Maheshwari, and Sanjeev Khanna. Justice Sanjeev Khanna also gave a dissenting opinion. But I have segregated every judgment in these three bullet pointers for you. We'll discuss how many judges were there on the bench, what were the legal provisions involved, and what was the ratio. Ratio means what was the ultimate decision that was taken by the Supreme Court. Um, so the legal provisions were Article 136, special leave petition. It was civil in nature, and the ratio is the part, the operative part of the judgment, where the reasoning is given for making a decision a certain way. So Central Vista Committee's decision of no protest and endorsement by the Delhi Urban Art Commission, and earlier endorsement by the Heritage Conservation Committee of the Central Vista Project, for which Prime Minister Narendra Modi laid the foundation stone on December 10, is without flaw. So these were the endorsements and the clearances, and also the consent that was taken, that was asserted by the respondents, and the Supreme Court held that all of that is without flaw, and the Parliament has full authority to take these decisions. And they'd gone through some CVC minutes of the meeting. Also, CVC is Central Vista Committee. Now, there were five major points that were raised by Justice Sanjeev Khanna in his dissenting opinion. While he agreed that, okay, yes, the compliances have been made, the no objection certificates have been obtained, and all of that, but he said that those clearances issued were invalid. The Central Vista Committee granted permission with premeditated intent. Premeditated intent means that they already knew that they will do what they wanted to do. So, there was no scope of any dissent or disagreement. Then not enough notice was given for the development plan. So notice to the public. So public was not informed well in advance. They were not given a lot of time to raise objections. Redevelopment of the Central Vista was proposed in the project. So it was proposed. The fact that it would be done was not discussed, and a lack of time hindered the public's ability to participate, like I just told you. And the Heritage Conservation Committee did not approve the project. So Heritage Conservation Committee, the entire purpose for which it is set up is to conserve, properties that have historical and heritage meaning to us, to the country in general. So that's like the national treasure, and the consent from their approval was not taken. So these pointers become very important. They can come in the form of MCQs, that who gave the dissenting opinion in this particular judgment, or what was the ratio, or what was ultimately decided. in this particular case, and the number of and the name of the judges on the bench can also be asked in your prelims. Of course, when you're preparing for your mains, you have to go in depth and also come up with linked judgments and precedents and other supporting legislations to back your answer. Next, we move on to another very important judgment of 2021. It's called Kirti versus Oriental Insurance Company Limited. So, just to give you a brief background of facts of this case, a couple, the man and a pregnant wife, they had been in an accident, and it was about how much insurance the um, deceased person's parents and their young children, 3 and 4 year old children, could get. And it was to be decided as per the Motor Vehicle Act. So in this, 22 lakhs had been given, which was challenged by the petitioners. And then the Supreme Court actually gave a very important observation, in which it was held that when you are determining the notional income of earning members and non-earning members, when it comes to deciding just what will be the fair, just compensation for the family, the kin and kith of the deceased people in motor vehicle accidents. Then you also have to take homemakers into consideration. Homemakers do add economic value, and they deserve recognition and respect. So the bench was composed of 3 judges: Justice N.V. Ramana, Justice S.A. Nazir, and Justice Suryakant. The decision was delivered on 5th of January 2021. The case number is right here. I would urge you all to note down the case number just in case you want to go through the judgment later. And I think you should. I mean, there is no shortcut when it comes to reading judgments. And while it may be time consuming, but at the end of the day, there are certain judgments that are worth it. And especially if you're preparing for your mains as a judiciary aspirant. And also in LLM entrances, sometimes you have to write subjective answers. So some judgments become very important and some judgments are beautifully penned. In this judgment, N.V. Ramana, Justice N.V. Ramana had given a concurring opinion. So he had penned down a concurring judgment, in which he actually categorically stated that as per the statistics, as per the census, as per all the surveys, there is a gendered understanding of home workers and homemakers, and the women constituted majority of those who were homemakers and who actually did unpaid domestic work, taking care of their children, taking care of the elderly, and doing other household chores without being paid, without being respected, and spend majority of their time doing that. Versus men who spent, generally as compared to women, they spent very little time doing that. So you cannot say that there is no scope of improvement or gaining experience or actually being of some value if you're a homemaker. So it was held that future prospect, like we discussed, that whoever has passed away, whoever has been deceased in a motor vehicle accident, and what would their income have been had they been alive, and accordingly they compensate the family of the victim. So, future prospect must be granted in case of motor accident of a non-earning victim, particularly with respect to homemakers. Women on average spend 16.9 and 2.6% of their day on unpaid domestic services and unpaid caregiving services for household members, respectively, while men spend 1.7 and 0.8% only. So this again becomes a very, very important judgment. A lot of questions can be asked. And the trend that has been followed by Supreme Court in 2021 has been very progressive, very inclusive, and very gender, very feminist, if you could call it that. And 865 judgments were delivered, like I said, and a lot of them have, really had the scope of encouraging the society, encouraging the people to be more tolerant, more inclusive, and to really act in a just and fair manner, given uh, the highlights of those judgments. And some of them will be discussed today. Kirti judgment was one of those judgments. So another important judgment now that we are going to move on to is Beggar Foundation versus Justice K.S. Putra Swami retired. So this was a review petition. Article 137 of the Constitution deals with review petitions. It also pertained to Articles 110 Clause 1 and Article 110 Clause 3 of the Constitution, and the entire Aadhaar Act basically. It was the bench comprised five justices: Justice A.M. Khanvilkar, Justice Ashok Bhushan, Justice S. Abdul Nazir, Justice B.R. Gawai, and Justice D.Y. Chandrachud. Justice D.Y. Chandrachud gave a dissenting opinion in this judgment, as he had done in the original Aadhaar Act judgment also. So again, this becomes a very important fact for you to remember when you are preparing for your entrances. This can be asked. So this was a review petition for the Aadhaar judgment that had come out in 2018. Justice Putra Swami and another versus Union of India was the name of that judgment, and that was also a landmark case. So it is very important for everybody to know, everybody in the legal profession to know what that judgment held. In that, certain provisions of Aadhaar Act were struck down as being unconstitutional. One of such provisions was Section 57 of the original Aadhaar Act of 2016, which actually made it mandatory for the linking of the Aadhaar card and your mobile number, and the ability for the government to use those details for any purpose they deem fit to identify the person. And there were certain guidelines that were given, which were a test of proportionality to balance out right to privacy versus the right of the government to actually know about the citizens, to actually provide subsidies and other welfare schemes to the citizens. So a healthy balance has to be struck between those two, national security and right to privacy. Another important judgment in this regard is the Pegasus case that's still pending. So, I mean, these are, certain ideas and certain ways for you to interlink different topics, and to actually use analytical thinking and your ability to form your own opinions and your own interpretations. When you do that, when you actually start linking one thing with another, and you start forming stories in your head and try to understand what it means to you and then analyze it, reading judgments becomes easy also. So you'll see, once you understand the significance of something, once you understand it like a story, it will mean something to you, it'll make sense to you, and you'll remember it. So it's very important to do that. So in that, yeah, like I told you, section 33, section 57, and section 47, if I'm not mistaken, they were struck down, and the rest of the act was upheld as constitutional, especially section 7 of the act, which said that the government can mandate Aadhaar card for providing subsidies and other welfare schemes to the people that needed those schemes. But any private organization could not mandate identification through Aadhaar card. So that was, broadly speaking, what was held in that judgment. So there was a review petition filed for that judgment, which challenged the constitutionality of the remaining provisions of the Aadhaar Act also, and they also questioned whether or not the decision of the speaker will be final and binding, or is there any scope for judicial review. So here, it was held that judicial review of whether a bill is a money bill would be admissible under certain circumstances. Those circumstances were given. So Aadhaar Act was held to be a money bill, and having regard to the law laid down by the court, Section 7 of the Aadhaar Act had elements of a money bill, and the other provisions were incidental to the core of the Aadhaar Act. Hence, the majority held that the Aadhaar Act had been correctly certified as a money bill under Article 110, Clause 1. And since it is a money bill and there's no scope for judicial review because there are other guidelines for that also over here, that is how um, uh, no interference is required, and yes, it is a money bill and it is going to be treated as such under Article 110, Clause 1. And the dissenting opinion that was given by Justice Chandrachud in this was that the dismissal of this petition without delving deep into the merits of the case would could be a premature dismissal of every related issue pertaining to the Aadhaar Act. So it also forecloses the scope for approaching a larger bench to get the benefit of the larger bench's consideration on the very issues that were raised as pertaining to the constitutionality of the entire Aadhaar Act 2016. So that was the dissenting opinion that was given by Justice Chandrachud. Now I can see in the chat box, Safa is here. Hi, good evening, Safa. Thank you for joining us. So if there are any questions, you know the drill. Just put them in the chat box. We are just discussing some really, really important judgments of 2021. For any of you who are joining us right now, it's okay, don't worry. You will be able to see the entire session from the beginning. But if you're joining us now, I would urge you to stay and follow the remaining judgments with me so we could interact with each other and you could uh, tell me your queries in the chat box and we could learn together. So the next judgment that we're going to discuss is Manishkumar versus Union of India. So this also becomes a very, very important judgment when it comes to the insolvency and bankruptcy code. So there were certain amendments that were introduced to the IBC code in 2020. These amendments were given under sections 3, 4, and 10. And this particular petition, writ petition, was filed under Article 142 against those amendments. So those amendments were impugned, and this judgment was passed by a three-judge bench, which was comprised of Justice Fali Nariman, who's retired now, Justice Naveen Sinha, and Justice K.M. Joseph. In the ratio, the reasoning and the judgment that had happened, judgment that had been pronounced in this particular case, the court upheld the impugned amendments. So the writ petition was dismissed, and there were certain directions that were given that could be found in the last few paragraphs of the judgment under Article 32 of the Constitution. So, broadly speaking, the amendment pertained to the fact that if certain home buyers wish to proceed against the builder or the entire company that they had bought some homes from, then under section 7, that is, and you'll have to go into the nitty gritty of the IBC to understand what is section 7, section 9, and since we don't have that kind of time, so I won't delve deep into that. But as we know, IBC was enacted to expedite and to also make sure that there is a proper structure being followed for winding up of companies and for their resolution process of their insolvency if they've declared themselves insolvent. And the court takes into consideration that a defendant or a person cannot proceed against his or her own company and declare to get it declared insolvent. So a major amendment that was proposed in 2020 was under section 7. There was a proviso that was added that said that if a home buyer wished to proceed against the builder to get the builder declared insolvent, then there must be a minimum of at least 100 home buyers, and if not, then there should be at least 10% of them, whichever is lesser, to file that application under section 7. Now this was contested by the petitioners saying that this puts the home buyers at a disproportionate at a disadvantage, because what if not everybody wants to proceed against the builder, and what if you can't really get 100 people, and it also adds to the procedural hindrances. So the entire purpose of this particular section, providing relief to them, um, is nullified through this amendment. And they also said that there was through these amendments, they are trying to say that home buyers are at a different footing than the people who are in debentures or who are security holders. And while both of them are equally financial creditors, so why is this amendment only pertaining to home buyers? That was the main argument of the petitioners. The court said that no law is perfect. At the outset, they said that no law is perfect, and especially there is full freedom for the legislature to do experiments when it comes to the business world, when it comes to laws that pertain to the business and the finances of the country. So there is no patent illegality. And another thing that was explained was that even if there are not 100 people, there are always alternate remedies available to home buyers when it comes to proceeding against their builders, which is under RERA, or also Consumer Protection Act. So it's not like they're remediless. And there are a lot of home buyers that are put at a disadvantage when the builder goes into or becomes insolvent, and the entire mechanism for resolution process begins. So what about that? So there was like a healthy balance has to be maintained, and nobody is being disadvantaged here, and these impugned amendments are upheld. So this also becomes important. Now we come to another really feminist and progressive judgment that was pronounced in Aparna Bhatt versus the state of Madhya Pradesh. The case number is right in front of you. And a very interesting part about this judgment was that it started with a very beautiful quote by Henrik Ibsen that said, "A woman cannot be herself in the society of the present day, which is an exclusively masculine society with laws framed by men and with judicial system that judges feminine conduct from a masculine point of view," by Henrik Ibsen. It was a very beautiful quote, and the judgment begins with the quote. Very beautifully penned. You should definitely read this one. The bench comprised, it was a division bench comprised of Justice A.M. Khanvilkar and Justice S. Ravindra Bhatt, and it was under Article 32 of the Constitution. So Article 32 and also 136. So in this appeal had been filed basically against the order, against the judgment of Madhya Pradesh High Court, where the judge had categorically imposed a bail condition on the accused. So a bail petition was filed, bail application, bail was granted on certain conditions, and one of those conditions was that the accused will go to the complainant's house along with his wife, and get a rakhi tied to him and promise the complainant to protect her as her brother, and also give her 11,000 rupees, because that's shagun. In When you get rakhi tied, you have to give a certain amount to your sister. So that was one of the conditions for granting bail, and that condition was challenged in this particular appeal, which was filed by Aparna Bhatt. And that judgment, that particular condition, thankfully, was set aside by the Supreme Court, and a set of guidelines was issued for courts dealing with sexual crimes. So, a very important point to consider in this particular case was that the petitioner, the appellant, brought to the court's notice how certain judges and certain judgments can be really insensitive by trivializing what a survival of sexual abuse or sexual assault or rape has gone through. by just giving their personal opinions, and being very biased in their judgments also. So there is a need for gender sensitization in the bench and also maybe the bar. And so the Supreme Court in the judgment categorically also said, called out for a gender sensitive curricula for anybody who is preparing to become a judge, and also who is a law student. So the legal professionals, the judges, the bar and the bench should be sensitive while dealing with sexual crimes. So that is why this judgment also becomes very important. Now we come to another judgment, which was Union of India versus K. Najib. Now, this is a very peculiar judgment. In this, the main point was that should the bail be granted to K. Najib or not. And the bail had been granted by High Court, which had been challenged by Union of India, and the Supreme Court then had to decide. The bench comprised of Justice N.V. Ramana, Justice Anirudh Bose, and Justice Suryakant. Now, why I keep repeating the names of the judges and the bench is because a lot of the times you're asked those names in the entrance exams, and also we follow a larger bench rule in the country, in the legal system, in the criminal justice system, in the civil justice system, basically in the justice system, where a larger bench has authority to overrule the decision of a smaller bench. So you have to know how many judges were there, and then if this particular judgment has to be reviewed, it will have to be reviewed by a larger bench, say 5 judges, 9 judges. The Aadhaar case, the original judgment that came out in 2018, that was a 9 judge bench. So, these things become important. Now, the provisions that are involved are Article 136, Article 21 of the Constitution, and Section 43D 5 of UAPA as well, which is the UAPA is also another very peculiar kind of a draconian law that is under a lot of discussion and debates. So you should know about this law. Um, yeah, I keep checking the chat box to see that, to make sure that you have not asked any questions yet. So what had happened in this particular case, a brief background of facts. After that, they went to the professor and they chopped off his right palm. And so he, along with other accused people, they were arrested. Under the main point of discussion in this particular case was, is it a violation of fundamental right to speedy trial? Um, is that violation a ground to grant bail? So K. Najib had already been in jail for 5 years, and there were 276 Supreme Court held that the bail can be granted, and we all know that bail is rule and jail is exception, no matter what the of the accused might be. And section 443D5 of UAPA was also discussed. It was compared with section 37 of NDPS Act, and it was held by the Supreme Court that between appellant's right to lead evidence of its choice and establish the charges beyond any doubt, and simultaneously the respondent's rights guaranteed under Part 3 of the Constitution have been well protected. So another connecting judgment to this is a landmark judgment, Hossainara Khatun and others versus Home Secretary 9. The citation is also on your screens, so make note of this. In this particular judgment, Article 39A, parts of Article 39A, they were moved to Part 3 of the Constitution, and it was held that everybody has a fundamental right to speedy trial. Moving on to the next case law, to the next judgment. I understand if you are sort of binge watching this video, then it can get a little bit, a lot for you. So I would suggest you take breaks and you make. Hi guys, so there was something wrong with my internet. I have reconnected now. So as we were discussing the important case laws, we were talking about Kanis Fatima and others, and Commissioner of Police and others. So in this, the review petition was dismissed, and the Supreme Court had held that you cannot protest anywhere and everywhere, especially if it's affecting the rights of other people. Now I have received a question in the chat box. Rucha has asked, is it necessary to remember all case laws if they are important? So you cannot possibly memorize everything, but I would suggest when you're preparing for your entrances, especially, and even if you're a legal professional, the practice that I follow is that I maintain a diary with me. And these days you're all very techno friendly and also digitally very interested and digitally inclined, so you could somehow have your own database and on your own record of the name of the case and the citation, along with the topic that that case comes under and what was the ratio, or what was actually basically held, even if you don't write down all the facts and the arguments and everything else that was held, because we are a common law country. We do rely on case precedents heavily, and every time we are going to court to argue a particular point, we have to back those points with precedents. And if we have our own database of sorts, or if we have our own record with important cases at the back of our head, we'll know that we could always refer to them. And that's why they become even more important in your entrances, that if you make those pointers for yourself, if you make your notes, even if you can't memorize everything, if you've read those notes once, then any MCQ that comes through that, at the back of your head you'll have an idea just exactly what is the right answer. So I would suggest that you make notes and you have your own database, own record of some important case laws. It's always going to help you in your profession. If you're practicing, if even if you are working as an in-house counsel, you'll know that okay, this was held by Supreme Court in this particular case, so you can't really be saying this, or you can't really be doing that. You can do that to the opposite party at the negotiation table also. And if you're preparing for entrances, there is no other way. Make your notes and always refer to them again and again, at intervals, at regular intervals, so they are in your subconscious mind. Moving on, now we will discuss Vikas Kumar versus UPSC, another very progressive judgment that was passed by Supreme Court in 2021. Note down the case number. So there was this quote from this judgment only, which said, "In their blooming and blossoming, we all bloom and blossom." So it pertained to the rights of the people with disabilities, and it also overruled an earlier precedent. Justice Chandrachud was on the bench, Justice Indira Banerjee and Justice Sanjeev Khanna. It was pertaining to a special leave petition that was filed under Article 136. So what had happened was, Vikas Kumar wanted to appear for UPSC exams, but he could not without a scribe because he had a condition that gave him writer, that is commonly called writer's cramps. So I think this phagia or this graphia is the technical term for this. I'm not too sure. So he had writer's cramps and he could not write the exam himself. So he wanted a scribe, but the UPSC said that no, you do not qualify as a disabled person under the Rights of Persons with Disabilities Act 2016, and that is why we will not provide you with a scribe. So Vikas Kumar then moved against UPSC and filed the appeal. He had, of course, gone to High Court before, and High Court had upheld UPSC's decision, and then he had to go to Supreme Court. So, in this equality and principle of reasonable accommodation, these are the keywords, and there is a lot of likelihood of this question being asked in the mains or even in the prelims, that what is principle of reasonable accommodation. Another connected question can be, when is the International Disabilities Day or International Day for Disabled Persons or persons with disabilities? When is that day celebrated? Or when was this act enacted? Or what was the object of the act? Or when did India actually ratify the United Nations Convention on People with Disabilities? So these are some connected questions that can be asked. You should be prepared with them when you're preparing for your entrances. And what had happened in this case, Supreme Court allowed the appeal, and Supreme Court held that there are only a few limited sections of the legislation which refer to Section 2, Clause R. There was no requirement that even the provision of a scribe, which would facilitate access to writing an examination, should be limited only to persons with benchmark disabilities. And this should be allowed to all persons with disabilities, whether or not his condition, which is a writer's cramp, would fall within the framework of benchmark disability or not. So, if you go through the act, or if you go through the objective of the act only, there are certain benchmarks that have been prescribed for different kinds of disabilities. And only when you meet the criteria as a disabled person will you get the PWD certificate, or will you get the facilities or the accessibility that is to be provided by the government. But Supreme Court said that there is a principle of reasonable accommodation, which means that you have to be reasonable and you have to be accommodating for people with disabilities, and you cannot rob them of opportunities just because they don't meet your benchmark criteria, which clearly overruled the earlier precedent, which was the case V. Surendra Mohan versus State of Tamil Nadu. The case title is on your screens, so please note that down as well. It is very important for you to remember this. What had happened in Surendra Mohan case was that it was held by the Supreme Court that if a person is suffering with 50% or more blindness or hearing problems, then that person is not fit to be a judge. So this particular judgment clearly overruled that and said that you have to have reasonable accommodation. You have to give them a chance to at least have equal opportunities and equal access to opportunities, and then based on their caliber and merit decide whether they're fit for the position or not, and not based on their disabilities. So again, this becomes a very, very progressive judgment. Before we move forward, I have a question from Safa. So Safa has asked, while writing legal analysis of a particular section, whether it is IPC or anything else, what is the best approach to interlink the judgment while a judgment holds more than one provision? So this is a very good question, Safa. So there's a particular structure that you have to follow, and I will not be able to go deep into explaining how to analyze judgments. But the structure has to be followed. There should be a brief background to the case. There sometimes you can involve what were the arguments taken by both the parties, and what were the main issues. So those issues have to be categorically addressed in your analysis, whether this should be this or whether that should be that. And if there is any other particular judgment that you're trying to and that you're reminded of while reading or analyzing this judgment, then you have to incorporate that judgment and those provisions in your analysis portion. Now, if you want to learn more about this, there is a YouTube video only that you'll find. You just search how to read judgments. So there was another session that was taken by me and Varshika, a friend of mine, where we had talked about making notes on judgments and reading them and making notes on them from a legal professional's perspective and from a law student's perspective. So analyzing the case was also explained in detail. I think you should definitely watch that video and you'll get more idea about this. But for now, I can just tell you that you have to follow the structure and you have to put forth your opinion only in the analysis part and not before that. So in the judgment, if more than one provisions are being disputed or discussed, or if there are any precedents that are being discussed in the judgment itself, then you have to make sure they are incorporated in the main issues that you are covering in your analysis. It can be tricky. So I cannot explain this right now because we have to move on with some more cases and we are running out of time. But you get in touch with me, Safa, at Law Chakra on Sanya, and I will guide you further on this. If anybody else also wants to know more about this, you can definitely reach out to me. So the next case that we are discussing is another very interesting case, guys. Very, very interesting. Okay. And I'd done this whole sarcastic post on this also, a very satirical one. So it was called Matter of Great Public Importance Touching Upon the Independence of Judiciary. I can't even explain this without, like keeping a straight face with all of you. So this was not a judgment; it was an order. It pertained to the ex-CJI sexual harassment case. So ex-CJI Gagoi. Um, we all know sexual harassment allegations were made against him, and what he did was that he took suo moto action and became a judge in his own case. And that's how this became very relevant at that point in a lot of entrance exams. This was asked that nemo judex in causa sua. So nemo judex in causa sua is the Latin. It's Latin for you cannot be a judge in your own case. So you cannot judge you cannot be the judge when you are being prosecuted or you are being accused of something. But he had done that, and then of course later that could not move forward, and it was titled Matter of Great Public Importance Touching Upon the Independence of Judiciary. And then Justice S.A. Bobde had taken over and he became the head, and a committee was convened under Justice A.M. Patnaik, which is called A.M. Patnaik Committee. A.M. Patnaik is also retired now. So the committee was formed to delve deep into the facts of the matter and the complaint that was filed by a complaint of sexual harassment against CJI. And an order was recently passed in this suo moto case, which closed the case. It closed the matter. The bench comprised of Justice S.K. Kaul, Justice A.S. Bopanna, and Justice V. Ramasubramanian. So, Supreme Court can take suo moto action under Article 32 of the Constitution. It was disposed, and the reasoning that was given was electronic evidence is difficult to recover after nearly 2 years, and the committee headed by CJ Bobre regarding the sexual harassment charges had already given its report. And the funny thing is that in the report, the A.M. Patnaik committee report, it was, it was clearly mentioned that, yeah, there were certain circumstances that should be probed. But those circumstances, of course, were not probed. And then recently, ex-CJI came up with justice for the judge. That also becomes a very important question for your entrance exams. Who wrote justice for the judge? So that is very ironic and very funny for me. But yeah, so Justice for the Judge was recently authored and also launched by ex CJI, who is now into politics, and the case has been closed. And this order becomes important for other ancillary MCQs that can come up. Um, I would urge you to read more about this particular case, just for the purpose of your knowledge and your own opinions. The next case that we'll quickly discuss is late Colonel Nitisha versus Union of India. This is also a very interesting progressive feminist judgment. Um, and the quote again is from the judgment. It said, "The structures of our society have been created by males and for males. As a result, certain structures that may seem to be the norm and may appear to be harmless are a reflection of insidious patriarchal system." And it's great that these things are being recognized and also spoken about by the Supreme Court, because a lot of the times, while we say that the law changes with the people, with the times, with the society, but sometimes interpretation of laws in a just and a fair manner can also help bring about a change in the thinking of the society. So that's why these judgments become very, very important. So what had happened in this case was that there was an earlier case, another landmark judgment, which was Ministry of Defense versus Babita Punya. It was civil appeal number 9367 to 9369 of 2011, and the judgment had come out in 2020, uh, which actually talked about the discrimination when it came to some perks and some advantages that are given to men and women in the army. To put it very, very simply, there are a lot of technicalities to it. The judgment deals with every single issue in a meticulous manner, so you'll have to read it to understand it better. But for now, just to keep it brief and give you a background, so there is this thing called permanent commission. Permanent commission is given to retired army professional, to people in the army, which gives them the benefit of having a retirement age in the army, and retiring only then. Until then, they can avail the perks and other benefits. So in terms of women in the army, there's a women short service commission. And earlier, women short service commission, they were not eligible for permanent commissions, and that was held to be arbitrary by Supreme Court in Ministry of Defense versus Babita Punya. And the Supreme Court actually gave directions to the army to change their rules and include women also, the WSSCO, to include them also for the grant of PC. And while they had actually done that, in a very subtle manner, in the criteria that the government came up with and the benchmarks that they had kept to grant permanent commissions to women, those were discriminatory, and those were held to be arbitrary in this particular case. So even though government complied and the army complied, and they came up with rules and regulations to grant permanent commissions to women also, but the criteria that they uh, upheld for women, that was discriminatory. And in this particular judgment, the Supreme Court held that the administrative requirement imposed by the Indian Army authorities while considering the case of WSSCO, which is the Women Short Service Commission organization, for the grant of PC, which is Permanent Commission, of benchmarking these officers with the officers lowest in the merit in the corresponding male batch, is arbitrary and irrational. So certain medical requirements were there, certain comparisons were made between women and the male who were also eligible to be granted PC, and the lowest rank of the male category was compared with women in granting them permanent commissions, and that was held to be arbitrary and discriminatory. In medical requirements also, it was not uh, developed or changed or evolved as per the biology of a woman. So that is why that judgment becomes very significant. Now, if you have any other questions, we are nearing towards the end of the session. I'll discuss the remaining case laws with you, but I will stick around for another 2-3 minutes to also entertain your questions and to have a conversation with you, hopefully, or to solve some queries for you. So you feel free to put your questions in the chat box. The next judgment that we have to discuss is Muhammad Salimullah versus Union of India. Quickly telling you what this was about. It was about Rohingyas, Rohingyas taking refuge in Jammu, in the state of Jammu, and this is a very important judgment because in this, the Supreme Court reiterated that Article 19, subclause 1 E of the Constitution applies only to Indian citizens and not to every person. Okay. So the bench comprised of Justice S.A. Bobde, Justice A.S. Bopanna, and Justice Rama Subramanian. And the interlocutory application. So an application was filed to give interim relief to the Rohingyas to settle freely, to be released from detention and to move around in the country under Article 19(1)(e). But it was dismissed, and Supreme Court held that right not to be deported is ancillary or concomitant to the right to reside or settle in any part of the territory of India guaranteed under Article 19(1)(e), which applies only to the Indians and not to refugees or foreigners. So this question can be asked: Article 19(1)(e) applies to dash, or does it apply to Indians or also foreigners, or what was held in this particular case? So you just, to give you a broad idea. Next is Forum for People's Collective versus the state of West Bengal. It was a writ petition. Dr. D.Y. Chandrachud and M.R. Shah were on the bench, and legal provisions that were involved were Article 32, 254, and 142 of the Constitution. This was about doctrine of repugnancy. So in West Bengal, the West Bengal Housing Industry Regulation Act 2017 was struck down because it gave the same reliefs and the provisions were overlapping with RERA, and if there are any overlapping provisions, then the Central Act prevails. So this becomes important for that. The next case is Election Commission of India versus M.R. Vijay Bhaskar. Another very interesting case where right to freedom of speech was upheld, and the bench was again Dr. D.Y. Chandrachud and M.R. Shah, and Articles 136, 19(1)(a) of Constitution were involved in this particular case, and the ratio. So election commission, so there was a case that was going on, and there were some oral remarks by the Supreme Court, where they had said that the election commission might as well be called a murderer, because they were holding elections and rallies while the pandemic was going on, and they were also COVID spreaders. So that was an oral remark which was actually published in a lot of articles, and it was captured by the media. So election commission moved Supreme Court first of all to take back those remarks, and also to prohibit or restrain the media from reporting the whatever goes on in the courtroom. So this appeal was dismissed, and the Supreme Court held that an open court ensures that the judges act in consonance with the law. So open court means free and fair access to whatever goes on in the court to general public, and that is also pertinent in regards to the debates that are going on in live streaming of Supreme Court proceedings, where Justice Chandrachud is totally in favor of that. So the apex court included the media reporting of judicial proceedings under the fundamental right of freedom of speech and expression, stating that it is a part of freedom of press. So with that, we come to the end of today's presentation, today's session, whatever we had to discuss. Now, if there are any questions, you can just put them in the chat box. Like I said, we could wait another minute for your questions. If there are no questions right now, and you're watching this video later, you can reach out to me at Law Chakra by Sanya. on Instagram or on LinkedIn, and you can discuss your doubts with me. Again, this is not an exhaustive list of important cases. There are other important cases also. So you can add to the list by sharing the cases that you think are important in the comments below. And if for some, if I can help you out with some resources pertaining to these cases, these judgments, important pointers or a tabular format of sorts. I did not get the time to make it as of now, but I will be making it. I will be sharing it on Laws of Sanya, and you can definitely check that out. Or you can reach out to me to ask for that. So thank you so much for sticking around, and I hope that it helped, and all the very best. We'll meet again tomorrow to discuss pleadings in Civil Procedure Code. So have a